The topic traditions of the court in Bombay is something which is nearest to my heart, and I've been doing research on this for quite a while. Let us now understand what is tradition. Tradition and heritage is something which is which has come to us from earlier generations and not now. So therefore, we have to look at it in a very careful manner and to see what exactly are the traditions which the British have given us. Before we go to the traditions, we must first understand that how the judiciary itself developed on Bombay. The history of Bombay as well as history of judiciary starts with the advent of Raja Bimba, the second son of Ramdev Rai of Devgiri, who came to Bombay and settled on the island of Mahim in around 1296. Along with him came four different communities, the Pathare Prabhus, a community to which I belong, Saukarshis, Paskarshis, and Parshikar Brahmins. All these communities came and they started residing on the island of Bombay. He constructed the temple of his patron goddess, Prabhavati, which is in today's context is Prabhadevi temple. At that point of time, Bombay was a group of around 7 islands. And the neighboring island, which is Matunga and Parel, on that island, Raja Bimba set up a law court in which he appointed a judge and he himself sat with the judge as like a division bench to hear the matters which were concerning the Bombay city. Unfortunately, Raja Bimba died in 1303. His son Pratap Shah did not continue to be associated with the court, I suppose, because we have no record as to what happened to the court. Only thing during his regime that happened was that he shifted the capital from Mahim, then called Maikavati, to a place which is still in existence by that name, called Marol, somewhere near Andheri. He was assassinated by his own brother-in-law, Nagar Shah of Cheul, and he ruled Bombay. The Nagar Shah ruled Bombay for a while. Again, there is no mention of any court or any tradition of the court which was started by Raja Bimba. Eventually, the islands passed on to the Mohammedans, that is the Sultan of Gujarat, in around 1534. Again, there is no record of any court established on the island, any of the 7 islands of Bombay during the Mohammedan period, but there were Qazis and Maulavis who actually conducted judicial proceedings. They administered justice in a summary manner. One cannot imagine as to what sort of a justice Mohammedan Qazi would impart in case of a dispute between two Hindus, say regarding succession or property matters. Anyway, that's how it continued. No court, so no tradition. Eventually, in 1534, as a treaty, the Portuguese were handed over the island of also at another island and other places. Portuguese also did not establish law on the island of Bombay. As per the scanty records which are available, there was a fort at Bassein which was constructed by the Portuguese. And in that Bassein court, which was quite huge in size, it appears that there was a place which you can call it a sort of a law court. Again, there is no details, no record, nothing. The description further says that if a person is not happy with the decision given by the Portuguese judge, then he would have had to file an appeal to Goa and then finally to the apex court in Lisbon. I cannot imagine that any case might have traveled in respect of a dispute on any of the 7 islands beyond Bassein, because in those days of communication and travel, it would have been impossible for somebody to carry the appeal from Bassein to Goa and subsequently Lisbon. So actually nothing happened during Portuguese period as far as judiciary is concerned. No court was set up, so there was no tradition which actually was in that time. There was a treaty between the Portuguese and the British in respect of an attack by Portugal, and they wanted the help of the British. Apart from other conditions and the hallmark of the treaty, the most important part was there were 2 things that happened. The thing is that Charles II married the daughter of Catherine of Braganza, and as a part of the dowry, surprisingly at that time also dowry prevailed, was given to the British in full ownership. British tried to a sort of a court which was two branches. One branch was somewhere near the custom house, which is not the present old custom house, but around that area. However, that also did not well. It was just a sort of a temporary arrangement to redress legal disputes that were happening in the Bombay. The British were, as it being it difficult to, they were looking for a how to get along with these islands, and then came a East India Company, who themselves were not very happy with their factory at Surat, and they wanted a place which was quiet, a place which had a good harbor, and a place they can do their business without any interference from anybody. They came to know that these islands had come to the British without any attached, so therefore they requested the British Crown to give those islands so that they can do their business. The British Crown thought that it was a good arrangement. They themselves were not in a position to quite the islands, and East India Company at that time, being a trading company, also were happy that they got possession of the Bombay Islands. In around 1668, by a proper lease deed, the second governor of East India Company, Gerald Ongier, that there were a lot of disputes pending. He wanted that the Portuguese law which should be discontinued and English law should be started. He requested the Crown to send a charter for establishing Bombay. Ultimately, in 1672, set up a court of judicature in Bombay, appointed a judge, and he himself, the governor in council, his own council, were the appeal court. This particular tradition of setting up a law court was started at that particular point of time. Tradition only lasted during the lifetime of Gerald Ongier. His tenure was a short tenure of 8 years. The subsequent governors who came, they really, being the appeal court and being the highest court, they were the one who were discharging justice and make money. Even at that time, corruption existed. Give justice to the person who is the highest bidder. In that situation, the judiciary itself, which was their practice, the island went into disrepute. Then they were on Bombay Island and they holed up at island for a very long time. Thereby, they completely crumpled the judicial system, with the result that the same was sought to be revived. But in Calcutta and Madras, the East India Company realized that temporary shaky judicial system should be replaced by a proper court. A request was made to the British Crown to send a charter for appointing a court. A common charter of 1726, Mayor's Court was established in Bombay, Calcutta and Madras. Funnily, the original charter remained in Madras. The Mayor's Court charter only provided for the judges were the East India Company officers, and they acted in a very summary manner. And although they were supposed to implement the British, they just used their common sense and tried to do justice, and most of the time they did injustice. In a criminal matter, if a native was found committing even a crime of theft, there was a chance that he could be sentenced to death. But if the similar crime was committed by an Englishman or an employee of East India Company, he would probably short, simple sentence or a fine. So this particular kind of justice that was doled out, the court unpopular among the residents, and it required a revised, and hence by 1753 charter, order Mayor's Court number 2 was established. This power which was given to the court to punish a person by way of a death sentence taken away, and that only lied in the and his council. At the same time, a small court was established called court of request, whereby not exceeding 15 rupees were decided by that court, and matters above 50 rupees were to be decided by the mayor court. But the charter also did not redress the grievance that there was no train. It only happened in 1798 when the East India Company realized that their business was increasing. There were more litigations taking place, particularly of commercial nature, and they required a court and a trained judge. So by Charter of 1798, Recorder's Court was established, and the recorder was a British barrister with 5 years experience of practice in England. So a trained lawyer came here as a judge, and the other persons on the bench were mayors and aldermen, who although were not as trained as the recorder, at least the recorder ensured that the justice was according to the British law. Now this is the tradition, actually the tradition of independent justice with a competent judge started. The passage of time, it happened that Bombay had not remained only as a city, whereby it stretched around Karachi in Sindh to around near Goa, near Sawantwadi in the south. One single court for the entire Bombay presidency. So it was decided they will split the court, whereby they will introduce a Supreme Court of Bombay to replace the Recorder's Court, and also they will introduce Sadar courts for giving justice to matters which originated outside Bombay city but during the Bombay presidency. So of 1824, Supreme Court was established, Sadar courts were established for the rest of the Bombay presidency. Now Sadar court was the highest court which sat in Bombay for some time, then again in Surat, and came back for hearing appeals from Sadar Amin, that means the like district courts in different parts of Bombay presidency. That particular Sadar court was presided over by the governor. A charter court presided over by regular judges, and Sadar court decided over, which was presided over. There were skirmishes between the governor and the, as well as the judges. Thereby, ultimately it was decided that this bifurcation was not healthy, and accordingly, by a charter of 18 in Victoria and subsequently modified in 18, the Bombay High Court was established. So this is the tradition that the court started in 1672, virtually a little while, and thereafter once the Mayor's Court was established, court was not perfect. There was an attempt made for improving the judicial system, improving the traditions. So these are the British traditions which were attached to all these courts. These courts had judges, they had barristers who practiced, they had British solicitors who came in with the, particularly after the Recorder's Court was established. So with them carried the traditions which were available in Britain as far as addressing the court is concerned, as far as the dress is concerned, as far as the other paraphernalia is concerned. So now thereafter, let us examine what are those traditions which ultimately filtered into courts in Bombay. So we had a composite court where all the jurisdictions were merged. So this very tradition of having chartered courts, and with every court, the implementation and dispensation of justice was improved. So now with this background, let us understand what were the traditions which were followed in the Britain and which were adopted in Bombay. Let us start with the very concept of wigs. There are so many people who keep on asking, what are these wigs? Why were they worn? When did they discontinue? Etc. So now let us see some illustrations and understand the very concept of wigs. Now wigs were basically, in the olden days in England, were made out of real hair or sheep's wool, and they were basically introduced because of, and they were worn because of loss of hair, and therefore they wanted wigs, and as well as for fashion sake, and it was worn both by men and women. So let us have a look at some of the wigs. Now you can see the kind of wigs that were worn by different kind of people. So there were the rulers like the kings, etc., wearing the wigs that were different. The common man wore very different. The members of parliament who wore the wigs were different. The ladies' wigs were different. So this is a collage of the wigs from one of the books of Ede and Ravencroft, who are the makers of wigs and other judicial paraphernalia in England. And this establishment is there for the last 300 years and still flourishing. Now this fashion of wigs actually came from France, and during the time of Henry III, whose period was 1574 to 1589. So this is Charles II, and mind you, these are not his own hair. He started wearing this wig, particularly probably to impress his Casino Braganza, around the time he got married. So his wig came with such a huge thing, which was called a full bottom wig, which was almost flowing above his shoulders. So this is Charles II. This is a picture of William III, who wore what is called a full bottom wig on a Roman dress. So he acted like a fashion icon, and that was William III, whose regime was 1650 to 1702. By the time the 18th century came, at the end of 18th century, the wigs had become short. Probably that little mania of fashion had drowned down, and the wigs became short. But still, the wigs nonetheless continued. So this is the general view of the wigs of those times. Now this is the wig of Sir Francis Syke, a member of Parliament, and which it appears became a sort of a model wig for the barristers to follow. So this has a big with buckles and curls, if you see them. King George IV, whose period was 1762 to 1830, he wore a wig of his own hair. So probably thinking that a day will come when he'll become bald, he already made a wig and started wearing it. This is the Lord Chief Justice Lord Lane wearing a full bottom wig. Now this is the kind of wig which continues to be worn in England. Now these are the wigs which were worn by the bench and the bar. Justice Davar, who was a judge of the Bombay High Court, had left this kind of two wigs, one of his barrister and one very big wig was the judge. And these two wigs were shown by me in the Supreme Court exhibition. Unfortunately for Bombay, I would say, in the lighter vein, that when Supreme Court museum was being set up, the Supreme Court had seen judicial artifacts coming from all over India and requested the Bombay High Court to send the wigs. At that time, Chief Justice was Justice B.P. Singh. He called me and said, "What do we do?" I said, "Send the small wig, leave the big wig for us." So the small wig was given away and the big wig has been kept and it is now put into the High Court Museum. Now let us come to the other paraphernalia, which is the gowns, the breeches, the black silk stockings and the black shoes with buckle. This is the view of Court of Chancery in 1460 with the Chancellor and Master of Rolls in scarlet robes. Now the scarlet robes will come to that, were also worn in India. So this is of 1460. Now this is a Court of Common Pleas again in 1460 with the Chief Justice and 6 puisne judges in scarlet robes. This is the Queen's Counsel QC in ceremonial dress, full bottom wig, silk gown, lace stock. In today's context, it will be the bands and the lace cuffs. You see the decorative cuffs. So that is the ceremonial dress for the Queen's Counsel. Now these are the barristers in bar wigs made of white horse hair and silk gowns. So this is a typical picture of what you will see outside the court in England. This is the High Court judge in full ceremonial dress. Now this is a kind of dress which was worn also in Bombay. You'll see in the High Court Museum quite a few judges who had done their portraiture are wearing this kind of dress, and you will be surprised that this tradition of wearing this scarlet gown continues in Calcutta High Court only at the time when a judge is taking oath. So there is a dress which is specifically reserved. When a judge is taking his oath from the governor, he wears that dress only for that particular occasion and then it is returned back. This is in the shop of Ede and Ravencroft. There's a worker who is working on the dress. It is the ceremonial robes of Lord Chancellor with black silk damask and gold lace filigree work that is being attended to. So these are the different traditions which were adopted either in toto or with a little modification in the Bombay High Court. Now let us turn to the traditions of barristers and solicitors. Solicitors also known as attorneys at law. The institution of barristers was present in England for about 1,000 years, virtually from the time the England was conquered by William the Conqueror in 1066. The practice of training the barristers was there in various inns which were there in England. Now those inns were eventually merged and ultimately there were only 4 inns in circulation and still functioning. Are the Middle Temple, started in 1388, Lincoln's Inn in 1422. Gray's Inn and Inner Temple have not mentioned any dates, but it is always presumed that all these four inns, they work in harmony and they were around the same time. Now, those inns had the authority to call a lawyer to the bar, control dignity, demeanor, and decorum of the profession. It conferred right to practice as counsel in England. Barristers were not supposed to be officers of the court. They could appear only after being briefed by solicitors, and barrister certificate was necessary for them to practice in Recorder's Court and appear as the subsequent courts, which were the Supreme Court and High Court of Bombay. So this was the tradition of the barristers practicing in Bombay. Unfortunately, in India or in Bombay, there was no institution which could substitute the inns. And even today, if some person has got the money and the desire to go to England and become a barrister, that is still possible. And now let us turn to the solicitors. Solicitors are nothing but the agents for their clients. The right to substitute as an attorney in lieu of personal attendance was permitted during the rule of Henry III, which is 1216 to 1272. So as early as that. Then during the reign of Henry IV, which is 1399 to 1413, attorneys were put on roll. The profession was regulated by passing of regulations regarding apprenticeship, examinations, qualification, admission, enrollment, removal, and remuneration. The profession was quite regulated by the time the 15th century came in. London solicitors thereafter started a law society in 1739, but it was incorporated by a royal charter issued to them in 1831 in England. Solicitors had no right of audience in the High Court and in superior courts in England. The British solicitors qualified from England started practicing in Recorder's Court, Supreme Court, and Bombay High Court, as I mentioned earlier. And almost till the beginning of the Bombay High Court, there was no Indian solicitor practicing either in Recorder's Court or in Supreme Court, almost at the fag end. And that too because of the effort of my namesake, Vinayak Harishchandra Jayakar, who was a native solicitor. The British solicitors refused to take him as article clerk, although he was otherwise qualified to become one. He even offered money to the extent of rupees 4,000 for being taken as an article clerk. He was not taken. Ultimately, he threatened to go to Calcutta because the Calcutta solicitor, British solicitor, offered to make him, do his articleship, and ultimately the Bombay judiciary realized that it will be very shameful that a qualified person was denied an apprenticeship as an article clerk and he had to go to Calcutta. The laws were changed, and ultimately in 1858, for the first time, the solicitors, native solicitors, were taken on the roll. There is a roll maintained by in the Bombay High Court of the solicitors right from the Supreme Court 1824 onwards. And the first person to be enrolled, although it ordinarily should have been Mr. Vinayak Harishchandra Jayakar, but another of his community man, Pathare Prabhu community, to which we all belong, Khanderao Moroji was the first Indian native to be enrolled on the roll of the solicitors. The second was Kamruddin Tayabji. Third was Vinayak Harishchandra, who fought all this litigation. And another Pathare Prabhu was the fourth one, was Shamrao Pandurang. So these were the four solicitors who were there at the beginning of the Bombay High Court in 1862. With the number of solicitors increasing, both coming from England as well as the native ones, it was decided by the solicitors in Bombay to establish a law society as a company under Section 26 of the Indian Companies Act of 1882. For registering it as a society, it required a license from the government of Bombay, and that license was given on 9th of January 1895, and the society was called Bombay Incorporated Law Society, which is still functional. Although the dual system has been abolished, we don't produce any more solicitors, but we do have article clerks who appear for a very tough exam, and ultimately joined the profession after passing that article clerk's exam. The dual system was abolished with effect from 1st of January 1977. You are aware, either as clients or as the lawyers who could be in the audience, that the practice of starting, or I would say the tradition of paying the fees of the council has been Goldmohurs. Now, how did this Goldmohur suddenly come up? So let us understand where this practice started. When the British barristers came to Bombay before the Recorder's Court in around 1798, 1799, why they started charging in Goldmohurs? Because while they were in England, they were in the habit of charging in guineas, and guineas was a gold coin. So now let us see from where these guineas themselves originated. Yeah, these are the four inns, and they have a common logo. So we have these different kings during whose regime these particular gold guineas were minted. The charter of Recorder's Court, and this is King George. This is King George III. Then we have the charter of King George IV, setting up Supreme Court in Bombay, and this is the logo of Bombay Incorporated Law Society. Now this is the gold coin guinea of King Charles II, issued during 1660 to 1685. This is the guinea of William and Mary, period 1688 to 1694. This is the guinea of William III, 1694 to 1702. This is the guinea of Queen Anne, 1702 to 1704. George II, 1727 and 1760. This is King George III, 1760 to 1820. Now I have stopped here the guineas because this is during this period that around 1798 or 1799, the British barristers started coming to Bombay. Now when they came here, obviously there were no guineas. So how did the Goldmohur come in? So let us see which were the very concept of Goldmohur came from where. These Goldmohurs came with the Mughals. So this is the Goldmohur of Akbar, period 1556 to 1605. This is the Goldmohur of Jahangir, period 1605 to 1628. This is the Goldmohur of Shah Jahan, 1628 1658. This is the Goldmohur of Aurangzeb, 1658 to 1707. This is of Shah Alam I, 1707 to 1712. This is Farooq Siyar, 1713 to 1719. This is Shah Jahan II, 1719. This is Muhammad Shah, 1719 to 1748. This is Ahmad Shah, 1748 to 1754. This is Alamgir II, 1754 to 1759. So now, these were the Goldmohurs which were in use at those time, and it is the last Goldmohur which was prevalent at the time of the Recorder's Court, and therefore the British barristers were paid in those Goldmohurs. Now realizing that Goldmohur was a popular coin, the British decided that they will have their own Goldmohurs, and therefore ultimately the British Goldmohur was minted in Calcutta in 1835 in two denominations, one mohr and two mohr of William IV. So these are the Goldmohurs of William IV. These are the Victorian Goldmohurs of 1841 minted in Madras and Calcutta. The only difference is that the legend which says Victoria Queen is continuous in the left one, and it is bifurcated, divided into the right one. So therefore they were called continuous legend and divided legend of 1841. Now the value of the Goldmohur was equal to 15 silver rupees in Bombay and 16 silver rupees or silver takas, what is called, in Calcutta. By 1670, Victoria had also not remained like a small child with a pony that was there in earlier profiles. So a matured profile was put on the coin of 1670 with a filigree work dress, and that was a Goldmohur which was issued after 1870. By 1877, Queen Victoria had become Empress of India. She did not remain only a queen, she became an empress. So all the Goldmohurs which were issued after 1877 which had legend which was called Victoria Empress. Surprisingly, in 1918, instead of a Goldmohur, a 15 rupee gold coin was minted in Bombay with a profile of King George V. Now, there was no coin issued in any form in gold coin during the short regime of Edward VII, that is the father of King George V. But this was issued as rupees 15 and was considered to be a Goldmohur. And surprisingly, the parity still remained between the Goldmohur and the value of silver, 15 silver rupee coins. Even Bank of Bombay issued a Goldmohur note, which was of rupees 15 in 1856. Now, this is a specimen of that note with two statuaries, the two statue pictures on the note, the left being Mount Stuart Elphinstone and the right being John Malcolm. They were the one who was there just before the issuance of this note in 1856. And these particular pictures are taken directly from their statues, which are there in the town hall of Bombay. So this is Bank of Bombay also coming out with a 15 rupee note, which was called Goldmohur note. This is a docket of a council signed by the solicitor with a marking of 1 GM in respect of application made by the barrister on behalf of his client in the recorder's court. Now, there is a humongous record of these kind of documents, which is maintained originally in the Bombay Archives, not now called the Maharashtra Archives, which is on the ground floor of the Elphinstone College building, where there are documents and records right from Mayor's Court onwards, not kept in very good condition. But at the risk of having some infection, I did go there and researched all this, particularly at the time of setting up the High Court Museum. And I found some interesting dockets. So this is just a docket for reference. Now let us come to the next tradition, the apex court, which is Privy Council and Federal Court. Now, again, the Privy Council, which is originally called King in Council, has been there again since the time of William the Conqueror, 1066. And the concept of King in Council is that they used to make law and they used to interpret law, because they thought since they made the law, they knew how to interpret the law. And that was the apex body for all the legal remedies for rectifying defects and miscarriage of justice at the hands of lower judiciary. Now, with the passage of time, King in Council was replaced by King in Parliament, which later on was called House of Lords, as the final court of appeal for litigation emanating in Britain. But King in Council or Privy Council continued in respect of appeals from the colonies. And since the litigation started increasing with the passage of time, ultimately it was decided that this particular Privy Council should be assisted, or rather be part of, a body called Judicial Committee, which was appointed in 1733 to advise the sovereign. So Privy Council consisted of Judicial Committee, which ultimately decided how the what judgment should be given. Now, this particular concept of Privy Council being the superior court or the apex court was there, kept in all the documents, all the charters. As far as India is concerned, right from Mayor's Charter to the Charter of the High Court, it was already mentioned that the final court of appeal will be Privy Council, and the appeal could be done by after High Court issues a certificate, and if High Court refuses to issue a certificate, and if the monetary limitation is satisfied, then one could directly go to the Privy Council and make a special leave to the Privy Council for filing an appeal. So this particular concept has been there in all the charters, not only in India, but in all the charters where courts have been set up in all the colonies all over the world. Now, there are certain facts which I am not aware whether the people are aware, that everybody thought that after independence, India became independent on 15th of August 1947, Privy Council also must have been disbanded. Answer is no. because from 1947, 15 August 1947 to 26 January 1950, there was no other apex court. So therefore, Privy Council continued to be the apex court in spite of India becoming independent. But in 1948, the process of reducing the overall power of the Privy Council was started by Federal Court Enlargement of Jurisdiction Act of 1948. Appeals from High Court could only thereafter be filed only before the Federal Court, but pending cases could be continued by Privy Council. Finally, the Constituent Assembly passed Abolition of Privy Council Jurisdiction Act of 1949 on 24th September 1949, which came into effect on 10th October 1949, whereby Federal Court, whereby all the matters which were pending before the Privy Council and which could not be disposed of before 26 January 1950, were to be transferred to Federal Court, and for that little short while, Federal Court became the apex court. It is surprising to note that since the matters which could be disposed of before 26 January 1950 were allowed to remain before the Privy Council actually disposed of the last appeal on 15 December 1949, a few days before the Supreme Court was born. Now let us see what is this Federal Court. Now Federal Court was a concept which was introduced for the first time anywhere in the colony in India, and by anywhere in colony in the world, where it was not an appeal court as far as High Court was concerned, and it was not an apex court because Privy Council continued to be so. Then what was the role of Federal Court? Federal Court was appointed under Government of India Act of 1935. Now immediately after the Federal Court was appointed, its jurisdiction was for deciding matters which were for interpretation of the provisions of Government of India, like the Constitution. It was the Constitution for India at that time. And also the presidencies were now bifurcated into provinces. So if there was a dispute between two provinces, then that could be brought before the Federal Court. Now after the Federal Court was set up, 3 judges were appointed. Chief Justice Maurice Guire came from England. Justice Shah Suleiman, who was that time the Chief Justice of Allahabad High Court, was also roped into the Federal Court, and M.R. Jayakar was directly taken from the bar to be the 3rd judge of the Federal Court. Now while doing the Supreme Court exhibition, I had the good fortune of going through the archives of M.R. Jayakar, which are now lying in the National Archives in Delhi, and I checked the files. There's a beautiful correspondence which is of interest, that the question was, what sort of a dress are these judges going to wear? Again, it's a question of tradition. By tradition, what was the dress worn by the High Court judges in England was followed here. By tradition, what was the dress of the ceremonial dress, that was also followed. Now, Federal Court was something for which there was no dress specified anywhere. So the 3 judges decided themselves that they will decide what the dress will be, and that decision to select the kind of dress, the color, etc., would be taken by M.R. Jayakar. Now, M.R. Jayakar was not in the profession of fashion or textiles. He contacted Asquith and Lord, which was a department store in the building which is just opposite to the university, where now the State Bank of Travancore, office of Wadia Gandhi, and the Ripon Club is situated. So on the ground and the 1st floor, there was a department store called Asquith and Lord, and asked them, Mr. Jayakar asked them to contact Eads and Ravencroft for certain designs and certain ideas. Eads and Ravencroft sent certain designs and suggested that the court dress may be of navy blue. The same was passed on to the 3 judges, and M.R. Jayakar recommended that we follow that, and eventually, as far as the court dress as well as the ceremonial dress was of the same color, that is navy blue, that was adopted. Now, we had the good fortune of having on the Privy Council 2 judges from Bombay, that is Justice Dinshaw Mullah, who started as a solicitor, then became a counsel, then became a judge of the Bombay High Court, and then he was elevated to Privy Council. M.R. Jayakar started as a judge of the Federal Court, and from 1937 to 39, and in 39 he was elevated to the Privy Council. So these are the two persons who went from Bombay to Privy Council. So this is the story of Privy Council and Federal Court. These are some of the traditions which have been followed. Some of them are amended. We still have those gowns, although the wigs are gone. We still have the senior counsel's gown, the judge's gown, in order to maintain the decorum and the dignity of the court, that we have still maintained this dress. So this tradition, like as I said in the beginning, like heritage, is something important which we must follow, and as far as possible, not dilute it unless the situation demands, and continue to follow it and pass on to the next generation. Thank you.
The first question is, it's interesting to find Gujarati print on the Goldmohur note of Bank of India. Can you please throw some light on the connected history on how did the language make its place on the note?
It is because of the Gujarati business people who had already set up a lot of businesses there. So we will have it in language of Marathi, Urdu, Gujarati, and English. These were the four languages which were normally used on the notes printed in Bombay.
What was the primary reason of wearing wigs in the Bombay High Court? Is there a specific reason, or were they adopted it for fashion reasons?
No, they were definitely not fashion, but those wigs were very regularly worn by the British judges. Indian judges started wearing them, then ultimately removed because it was not compulsory. But let me tell you, if I was a judge, I would still wear it today. It's the tradition that is important. A person sitting with that wig on gives a little different impression, in my opinion.
Devanagari language firstly used in courts by many cases from rural areas in India. Any translations can now used by the courts are available in Devanagari script?
Yes, we have a separate department for interpreters and translators, and that was functioning during the British time. We had interpreters who were constantly referred to because the British judges would not follow the languages, particularly while sitting as appeal court judges when they were dealing with appeals from the lower courts, or even in different languages when the documents came before them, even on the original side. So therefore, this particular department was functioning, and it functions today also. I'm sure now the official languages in India are so much that if you must have a very competent translation and interpreting department in the High Court, which we have.
When can we expect your book on Mumbai legal history?
So maybe by the end of this year.
Another question is, the paintings hanging in the Supreme Court bear that you have been instrumental in the same adorning walls. Can you throw some light?
They are not actually paintings. They are copies of the engravings which were there, which I had shown them from my personal collection during the exhibition in the Supreme Court. And that was noticed by the judges there. And the Chief Justice requested if they could have the copies, and said that we will say that this is courtesy so and so, to which I had no objection. I gave them the scanned images to the best of my ability, and they are hanging there.
Now, a technical question asked, what's the difference between presidency and provinces?
Initially there were three presidencies: the Bombay, Bengal, and Madras. Provinces came subsequently when the presidencies were bifurcated, like the presidency of Bengal became Orissa and Bihar on separately, etc. Then we had a central province. Then we had the northwest province, northwest frontier province, which is Peshawar and all that cases. So it was bifurcated into smaller provinces much later, because the British Empire started with these presidencies, and then as they started taking more and more territories, either by force or by there being no substitute to the ruler. Then even the rulers had a British resident sitting there on their head, like a watchman for them. So because of this, the provinces emerged, and ultimately the provinces became states.
Is the tradition of giving dockets to council also borrowed from England? What's the significance of the docket?
Yes, it is definitely borrowed from England, because I showed you the one docket of Recorder's Court, and this particular thing is definitely the only thing. The difference is, as far as this is concerned, and if there are any senior counsel listening to it, they'll probably frown. is in those days the solicitors used to mark the briefs, and now the councils mark the brief and return it back. So that particular practice of marking the brief also was originally, traditionally, the solicitor themselves used to mark it. And the docket is a sort of a brief summary of what is inside. What is that? What does the docket show? Docket shows which is the court in which you are going to, counsel is going to appear. What is the number of the suit or the appeal? What are the parties who are there in that? It is before which judge? What is the date on which the next date is there? What is the position on the board? And is it for the counsel is going to appear for plaintiff or the defendant? Name of the counsel. If there is any junior who is going to appear, then his name is added to it. And eventually the solicitor or the advocate on record who has sent these papers, his name also appears. So this, at one glance, the counsel comes to know as to what he's supposed to do. And thereafter he can open the brief and then read and be ready for the argument. So this practice is a very healthy practice, British practice, but it continues to be there and it is good.
So can you enlighten us when and how we moved from red and blue gowns to black gowns?
There was no red and blue gown. Blue gown was only there in the federal court. Red gown was there. Now it is called ceremonial gown. But the red gown was worn by the judges, particularly the High Court judges, when they were sitting in session. There was no session, City Civil and Sessions Court during British time. It came in only after 1948. So there was the Magistrates Court and the High Court. So High Court had original criminal jurisdiction for serious matters like murder or sedition, etc., where the sentence was going to be more than 2 years. So when the High Court judge sat into sessions, that time he wore a red gown, and that practice also was there in the initial stages. Thereafter also that practice was discontinued, although the gowns continued to be there. And if you see the portraiture, whenever most of the judges who sat for their portraiture being done, they were wearing that red gown because it looks little different, the scarlet gown.
Is it true that the gowns of advocates had a pocket where the clients had to put Goldmohurs in the said pocket if they were pleased with the outcome of the case?
That is just a rumor, because of the shape of the gown is such that there is, for a senior counsel, there is a flap behind, was considered to be a sort of a pocket. So if you want the counsel to go on with the matter longer, you put on, it's like a machine that you have in gambling houses, where if you want to play more, you put on the currencies. So therefore that is what was said. But I don't think that was the case, because in the olden days the brief was already marked, so there was no question. And when this practice of counsel marking the brief came, they did not require this petrol for their car to start. At the end of the matter, they would anyway mark the brief and send it. So this was it's only a rumor. I personally don't feel that such a practice exists.
So how were judges addressed at that point of time, earlier days, and is there a difference in the way we are addressing them now?
The judges were addressed as Lord, although we are not technically required to say so, but it is a practice. And instead of saying the sir, if you call a judge a Lord, he's not going to mind it. So therefore, this practice of saying my Lord and your Lordship pleases, etc., is a British tradition which we have continued. And I would say that's a good tradition, because a person who decides your fate has to be either a judge or a god. So therefore, might as well call the judge a god.
Another question on the solicitor system. Is the solicitor system still prevalent? How does one become a solicitor?
There are two questions. Whether it is prevalent, answer is that there is no solicitor system prevalent, but the practice of client going to a solicitor rather than directly going to an advocate who practices directly, particularly in commercial and heavy stake litigation, is still prevailing. And if one has to become you can't become a solicitor, because you become a solicitor by signing the roll, which was maintained by the High Court. That roll is now closed with effect from 31st December 1976. So you can't technically become a solicitor. But the training that goes into the making of a solicitor by signing articles with a solicitor firm, appearing for a tough exam, after which you get a particular certificate of having passed the article clerk's exam, is still prevalent. And you will be surprised that we have hundreds of article clerks appearing for the solicitor's exam. I remember when I became a solicitor in 1975, the solicitor exam used to be held in our law society premises. About 30-40 people used to appear. Now the exam has to be held in various colleges, because more than 100-150 people appear at a time. So although nobody is going to become a solicitor, the very concept of passing this exam, going through this tough career of studying, etc., is still prevalent. Although the people fail, it is not taken as a failure. They again get up, they again start studying and again appear for the exam and they pass. The only advantage that I see is, first thing is the rigorous training. If you are actually going into commercial and that sort of a litigation, then it is highly recommended that you go through this grill of passing the article clerk's exam. And secondly, if you are going out of the profession and taking a job in a commercial organization or in a bank or something, backed with a article clerk certificate, passing the article clerk exam certificate, is definitely preferred to a person who is only LLB of Bombay University. So this advantage is definitely there. So if somebody wants to become solicitor, he may not become a solicitor, but by passing the exam, he is not going to be any less. So it's advisable that he goes through the grind if he wants to really take the training.
Can you throw light on the system of barristers in the UK?
I think I elaborated it to the best of my ability in this, because
Sure.
barrister was not the main topic. It was one of the tradition of barrister that I said. But barristers are still there in England. The dual system very much continues to be there. And the only the changes that keep on happening is that now there are exams which are much tougher than what they were a few years ago. And quite a few of our freedom fighters were barristers. And this barrister as an institution, I can sum it up in one sentence, as it is a school. It's like a finishing school where a man enters as an apprentice and comes out as a gentleman, because the 3 Ds, the demeanor, the dignity, the decorum, this is something which is not only taught there but which is seen. And the dinners that they have, our dinners are not only for eating and appreciating the menu. The people who are eventually going to allow you to come to be called to the bar are watching you, whether all the 3 Ds, not only in the court but in your normal behavior, even at the dinner table, are there for everybody to see or not. That is seen. So that is how the thing is conducted in England.
So can you talk about when was the Nagpur bench set up? And
yes, Nagpur. Yeah, Nagpur. Actually, Nagpur was a high court for central provinces. So when the various states were reorganized in 1957, and ultimately Maharashtra became a state by bifurcation of Bombay state into Gujarat and Maharashtra, a portion of Madhya Pradesh was taken in, where Nagpur High Court is situated. And since it was included, the High Court, Nagpur High Court, was reduced to a bench, because you can't have 2 high courts in the same state. So when Nagpur became part of Maharashtra, it became a state. You'll be surprised to note that there was a Bombay bench in Rajkot for 3 years, because after the reorganization of the states in 1957, that particular portion for the litigants in the Gujarat part of Bombay state were still far away from Bombay, because the High Court was in Bombay. So a bench was set up in Rajkot for 3 years. Till ultimately Gujarat was, the Bombay state was divided into Gujarat and Maharashtra. So Nagpur was very much a part of which was a High Court, and then subsequently became a bench of the Bombay High Court.
So there are tablets of John Duncan in Verity and others which are put up. Was it commemorative of the services at the bar?
Yes. Now, John Duncan in Verity was a lawyer who was born in Bombay. He practiced for almost 50 years in Bombay and died in Bombay. Now, he was not only one of the, but I would say the most leading advocate during from 1870 to till the time in 1923 or something he died. Till that time, he was the most leading advocate, and his memory was so sharp that there is an instance where he would not take down any notes. And if he found a junior taking down the notes, he would tear them off and tell him that, please remember, don't take down the notes. And he was a very colorful man. He was a shikari. He didn't have a permanent residence in Bombay, that he did not own it, but he stayed at Baikala Club. And he was a bridge player and always ready to help juniors. He even accepted briefs on the appellate side. Appellate side lawyers also consulted him, and he died with his shoes on. One afternoon, at the time of the lunch break, he was walking to his chamber, and suddenly he started feeling giddy. He was about to fall down, and a solicitor just caught him and told him that, so he said that, I'm not feeling well. Please take me to my house take me to my residence in Baikala Club. Solicitor, seeing that he was running temperature and he was not well, instead of that, he took him to JJ Hospital. He was so furious. He said, I told you to take me to my house. Where have you taken me? But then the doctor gave him an injection and made him sleep. He requested the solicitor to go back to the chamber and please ask his peon to return all the briefs which were given to him for next day and say that I am not well. After I become well, I'll see the briefs. Unfortunately, the man died the next day. So he was one of the most leading lawyers of Bombay.
Do you see customs and traditions crumbling now, sir?
Yes, if you see it from a very strict point of view, yes, they are crumbling because people have started doubting their efficacy. People have saying that this is not required. People have suddenly say this is foreign, this is not Indian. So like the statues of British functionaries were removed from the Bombay streets, they want to remove all the British traditions also. So well, if that is the attitude, because the tradition can only survive if majority of the people feel that they should survive. If they feel that they should not, they will just go away.